Welcome back to another episode of Divorce at Altitude. This is Ryan Kalamaya. This week, I am joined by my esteemed co host and business partner, Amy Goscha. Amy, what are we getting into today?
Today, we're talking about relocation cases. You and I have talked about how these seem to be common, especially up in the mountain area.
Indeed, we thought, given that I had just come out of a trial on parental relocation, and we'll define what exactly we mean, that we should try to record an episode where we discuss the various kind of ins and outs. We do have a how-to episode on this. This episode's going to dive into those issues in a little bit more detail. But Amy, for people that don't know, how, from your perspective, would you define parental relocation?
There is a definition about what that means, and it essentially breaks the geographic ties for parents to easily parent their children. And that's not the exact language, but that's the basics of it. So, a lot of times in the mountain areas, you'll have towns that might be 45 minutes away. So, just depending on the location, if you're in New York City, you could sit in traffic for 45 minutes. So, it's not like a minute or a mile, but it's different in every kind of locality.
Yeah, indeed. I think different states have different definitions. In Colorado, the way that we define parental relocation, really what we're talking about is, and one of the factors under 1410-124 is the physical proximity of parents to one another. And if Eric and Melanie Wolf go through a divorce, then of course Eric or Melanie is going to relocate. But are they moving down the street, or are they moving across town? Or are they moving to Houston, Texas, or New York City? Obviously, neither of those places are in Colorado. And so we'll get into the practicalities of that. But when I talk about relocation cases, I'm thinking something about where it substantially changes the dynamic, where Eric cannot take Johnny and Sally to school every day if he has a week of parenting time. It's because he lives in Florida, or even, and we can talk a little bit, if Eric lives in Aspen, where I am, and Melanie moves down the street from you, Amy, in Denver, that is going to substantially change. Now, that's going to be a different relocation than New York City versus Boulder, for example. That, when we're talking about relocation, we'll get into some of the nuances, and that within the state of Colorado, there's going to be some practical considerations. But I think it's really important for people to understand, and one of the key takeaways is that there is a substantial difference between a relocation where Eric and Melanie Wolf are in a divorce, and Melanie in the divorce says, I want to move to Washington, D.C. And that is different than 5 years after the divorce is finalized. Then Melanie says, I want to move to Washington, D.C. Amy, why do those matter under Colorado law?
It matters because it's much harder to quote unquote relocate if it's 5 years after the divorce. If you're going through a divorce, essentially what the court and evaluators have to look at is, okay, mom is going to be in this location, dad is going to be in this location, and what is what parenting plan is going to be in the best interest of those children. Versus after the divorce, the court looks at the reason. Why is mom moving to Texas? Why is dad moving to Denver? So it just becomes a lot harder once the divorce is finalized.
Yeah, and for listeners, the reason is that in 2005, the Colorado Supreme Court issued two different opinions on the same day. One was Spalmer v. Gillette. That was a case during a divorce. And then on the same day, the court issued In re Marriage of Cheslake, and that was for a post-decree relocation case. That provides guidance for the trial courts, and in turn, us, Amy, as family law professionals, where we refer to, if I call you and say, hey, I have a Spalmer case, let me talk to you about it. What am I talking about, Amy?
That's pre-decree, meaning during the divorce.
And the Spalmer court said that what happens is if Melanie wishes to desire or wishes to relocate to Washington, D.C., then the court assumes that she's going to be there and then employs the best interest factors under 1410 124. And so for listeners that aren't familiar with, that's going to be number one, the wishes of the child's parents as to parenting time. So you're going to look at what does Melanie want if she's in Washington, D.C., and what does Eric want if, for example, he's in Denver? And of course, Melanie is going to want what, Amy, in that circumstance?
She's in Denver to be in Denver.
If she's in Washington, if she wants to be in Washington, D.C., sorry, but that she wants the kids to go to school with her. And that really is going to drive it is there's usually a school time parent and then the parent, the non-resident or the basically the loser for the parent. If it's Eric, then we're talking about summertime and we'll get into some of those kind of dynamics. But then you get into the wishes of the children to the extent that they're sufficiently mature to express a reasoned and independent preference. Number three, the interaction and interrelationship of the child with his or her parents, his siblings, his or her siblings, any other person that may significantly affect the children's interest. You're getting into grandparents, other nannies, caretakers, and then domestic violence, whether or not that is something that's going to really matter. The child's adjustment to his or her home, school, and community, the mental, physical health of the individuals involved. And really, this we'll talk a lot about this, Amy, the ability of the parties to encourage the sharing of love, affection, and contact between the child and the other party. And then you get into the past pattern of involvement of the parties with the child, in which whether it reflects a system of values, time commitment, mutual support. That then gets into who took the kids to the doctor and who spent what time. And if we're looking at a traditional arrangement, that really often is going to provide a huge advantage to Melanie. If she was a stay-at-home mom, then she's going to really have an advantage there. And then the ability of each party to place the needs of the child ahead of his or her own needs. Amy, if Melanie wants to relocate to Washington, D.C., what are some of the factors that Eric is going to really lean on in arguing that she shouldn't be able to, or she can relocate? Just everyone should understand that Melanie has a constitutional right and she can leave and she's going to leave. It's just a matter of when. It's just a matter of whether the kids primarily reside with her in Washington, D.C., or primarily reside in Colorado. So, what are the things, Amy, that Eric is probably going to be arguing?
Eric's really going to paint for the court the picture as to why the kids' lives where they're at is best for them and why changing it really is not in their best interest. Really focusing on this move is really about Melanie. It's not about the children. And also, it's going to deteriorate the love, sharing, and affection that the children have with their father. So he's really going to focus on the connections to how he is as a parent, family members, school, their friends, and why does that need to change, but for Melanie just wanting to do that.
Yeah, and some of these arguments or strategies that Eric is going to employ are certainly applicable in a Chesley case, which we'll talk about next. But Eric's going to try to slow things down for sure because the kids, absent an order allowing them to relocate, because the court has jurisdiction over the children and parenting time. The court can say parenting time is going to take place in Colorado. I'll come back to that. And so listeners should put a pin in that concept. But Eric's going to say, I'm going to slow things down. He might ask for a PRE, CFI. We're going to talk about experts. But if the children start school, for example, then the court is going to be reluctant to pull them out of school. And so there's going to be some timing considerations. The reality is that, especially during a divorce, the rationale is that things get tossed up, they're chaotic. The Eric and Melanie, they're changing where they're living, their relationship with their children is just inherently going to change because of the divorce process. And kids are resilient. And the rationale goes that this is just another layer of change. It just escalates the change, but it's part of the divorce process. And the court in Spalmer went through this constitutional analysis and looked at Minnesota and some of these other states. And people are, it used to be there was a case that kind of presumed that Melanie could not leave. But that was changed, and there is a tendency people are more now, and so these cases frequently do come up. And Amy, you see it, but I see it a lot up in the mountains. There tends to be one person that either is from here or just loves the outdoor mountain lifestyle. But a common kind of story is that someone comes here, whether they come after college and it's come for the winter, stay for the summer is a common thing we say. And then they go through a divorce and they're like, I am done with snow. I don't really enjoy skiing, or I'm not really into this. And it's really expensive in these mountain communities. It's really expensive. And so Melanie will say, I want to go back closer to my mom and dad and have my sister be able to help me take Johnny and Sally to school. And the cost of living is lower. And I just am, it's a small town, and I don't like the gossip or whatever that might have been subject to the divorce, or things that were shared during the divorce. Other people know about it for a variety of reasons. Could just be like, I'm out of here. And they could say also that the job pool is fairly limited. And so they're going to look for other horizons and start a new chapter. Any of that resonate with you, Amy?
Oh, yeah, all of it. And also the schooling. I think there's arguments for there's not, or sports. If you have a kid that's very talented, I can't provide, I have to travel 2 hours just for sports. So all those kind of considerations come in.
Right. Now, if we contrast that with Cheslek, so Cheslek again is a post decree. So if Melanie wants to move to LA after the divorce, then in addition to the factors that I mentioned under 1410 124, the proximity and the other aspects that come into play, then we have an additional set of factors. And this is why, Amy, a lot of family law practitioners say that it's harder in a post decree situation. The other thing I'll mention, that regardless of the pre or post decree scenario or relocation, there is no presumption that a mother or a father is better for the kids. That is just the case. But a lot of people will ask, can a mother really relocate, and doesn't she have an advantage? But in any event, going back to the additional factors under Cheslek, those are under 1410 129, and we get into the most obvious question is, why does Melanie want to leave? And so you get into what her reasons are. And by the fact that it's in the statute on post decree relocation, a lot of people will argue you're not allowed to get into that. On the pre decree, the Spalmer case, the relocation in the divorce, one would argue for Melanie in that, going back to the relocation in the divorce, you would say you don't get into why she's relocating. It doesn't matter because it matters for post decree, and it's not explicitly listed under the statute on post decree. So that's at least one of those arguments. Amy, any thoughts on that?
Yeah, I think though Eric could argue, like, still one of the main factors that's very important is putting the needs of the kid above your own. So I still feel like you can get that information in through that factor.
I totally agree. And it's one of those things where, depending on who you represent and how one of the things, whenever I tell people, yeah, I've got a relocation case or this or that, everyone wants to know, like, why do they want to leave? And the judge is going to want to know that. And one of the factors under 1410 124 is any other kind of issue that could impact the children. And so you can backdoor in, but it is explicit factor under 1410 129 in Cheslek post decree relocations. The second factor is the reason why the opposing party is objecting. So why is he objecting? Then you get into the history and quality of each party's relationship with the child since the previous parenting time orders. If you have a parenting plan and it has equal parenting time for Eric and Melanie, there's going to be a real analysis of, did Eric or Melanie, do they exercise their parenting time, and what's the history and quality of their relationship? Then you get into another factor. Amy, you mentioned this earlier, the educational opportunities for the child at the existing location. So, where are Johnny and Sally going to school? And then the proposed new location. And I'll stop there. And you get into there's greatschools.org, there's niche.com. You can have, especially for public schools, you can have these ranking services and you can compare the ratings and you can look in, you're talking about student to teacher ratios, private school versus public school, those sorts of analysis. And you can get into exhibits and how you marshal that evidence through in terms of the educational opportunities. Amy, any comment on that particular topic?
Yeah, you mentioned it's what's interesting when I've looked into this topic, even call it like entities that will rank colleges are starting to also produce rankings for like elementary school as
Yeah,
well.
US News and World Report, they have these rankings and you get into the testimony about good schools and various arguments about what's the better school. And then you've then come moving on to the other different factors is you have the other factor is any advantages of the child remaining with the primary caregiver. That factor is neutralized if you've got an equal parenting time arrangement. Then you get into the anticipated impact of the move on the child. So you get into the personality of Johnny and Sally and how they've done with the divorce, the change, whether they're social or they're homebody and the anticipated impact of that move. And of course, Melanie's going to say, oh, they're going to do wonderful. It's not going to be that big of a deal. And then Eric's going to say it's going to be a huge deal. That the kids are going to really struggle. And we'll come back to that. The other aspect is whether the court will be able to fashion a reasonable parenting time schedule if the change requested is permitted. If you're talking about if Eric lives in Aspen and Melanie lives in Boulder, that is a different arrangement than Eric lives down in Alamosa, which is really isolated and far away compared to Nantucket, where there's going to have to be multiple planes exchanged, and the travel there is substantially different than Denver to, I don't know, Chicago, where there's direct flights. So you're going to look into those kind of practical considerations. Amy, any thoughts on whether the court will be able to fashion a reasonable parenting time schedule if the change requested is permitted?
I think that's where it comes into when you were talking about the school-based parent versus the kind of holiday and summer break based parent. It just looking at the practicalities of two people in different states, that's why you see those types of parenting plans.
Right, and the age of the children is gonna really matter, not only because an older child might have more say in what they wanna do, but they also one aspect that we can look into is this concept, and this kinda leads us into a discussion about experts, is the concept of social capital. There's a lot of reviewed research and other things out there. Bill Austin, Dr. Sol Rappaport, who have written various articles about the impact of relocation on children, and two kind of main concepts come up, and one is social capital. So how long a child, if you're talking about moving a 15-year-old who has grown up and they have a robust friend network, they've been playing lacrosse or hockey or whatever it is, and you're looking at moving them, then and they're doing well in school, that is a different analysis than a child that is 7 months old or 2 years old and they really haven't established that friend group. That absolutely is going to come into play. But then you also talk about the practical considerations. Can a child get on a plane and fly on their own direct? If they're 10 years old, then they can do that. They might have an unaccompanied minor. If a child is 2 years old, obviously they're not going to be able to travel on their own on airplanes.
And I would say that when you're talking about social capital, there is also established research that says when you change a child's school, it sets them back at least 6 months.
Yeah, and we certainly have seen there's multiple relocations, so the risk of a child having some potential challenges and issues is increased the more relocations that occur. There can be multiple relocations. But then you also get into the second concept that it comes up is a concept called gatekeeping. And there's different kinds of gatekeeping. There's restrictive gatekeeping, there's protective gatekeeping, there's facilitative gatekeeping. And really restrictive gatekeeping, Eric is going to argue, Melanie is trying to restrict my access and restrict the children's relationship with me by virtue of a relocation, and inherently a relocation by Melanie, whether it be Miami or Chicago or Seattle, is there's going to be this argument that this is about you, Melanie, what's best for you, not what's best for the children. And there's always this argument about that children should be around parents. In the peer reviewed research suggests that children do well or do better, that they need to have at least 30 to 35% of the time with a parent to have a meaningful relationship. Of course, there is less. And you can also, it doesn't necessarily mean that if you have more than 35%, that you therefore have a great relationship with your child. There's certainly parents out there that have more than that that really struggle. But those are some practical considerations that really come up in relocation cases.
Yeah, I think that the gatekeeping one is a big one.
And Amy, what are if we're switching gears and we talk about experts, what experts can we expect, or what experts are we looking at as potential options in a parental relocation case?
You can have a child and family investigator. You can have a parental responsibility evaluator who can come in and can essentially render, make findings and a recommendation as to whether or not the relocation is in the children's best interest. And then you can also have a work product expert come in if you don't agree with how the CFI or the PRE their recommendation.
Yeah, and the final expert, I just relied on one in a recent relocation trial, was essentially a blind expert or an educational expert. And so my expert talked about the research on relocation, and then we had a series of hypotheticals that were based on the case, but the court learned about the peer reviewed research and the social science that exists about social or about parental relocation and restrictive gatekeeping. But if we go back to the PRE versus the CFI, one of the questions that Eric and Melanie are going to have to deal with is, do we have this PRE travel? Does the PRE or CFI, do they go to Honolulu, Hawaii, where Melanie wants to relocate and scope out and one of the questions that PRE is going to have and the court's going to have is, okay, Melanie, do you have a house there? Or is this just like an abstract? And so they would go there and they would research or have an idea of what the life is going to be like. And one of the questions or one of the things that the court or that really the evaluator is going to look at is, have the children been to this place? Have they been going back? Is it every summer they've gone back there? Or they spent a substantial amount of time? And that kind of gets into the travel component, because the travel can really increase costs, especially when you have Google Earth and the ability to research online. A lot of the experts with Zoom or other things, they can do a pretty good job of evaluating what life is going to be like there. Any thoughts on that, Amy?
Yeah, I think just to you can have the PRE travel even pre-decree if the divorce is finalized. It doesn't have to be just post-decree. But I do think that after COVID and use of technology, we are seeing maybe that they're not going to need to travel as much because it does create a lot more cost for the party.
And these relocation cases can get extremely expensive, but Eric and Melanie, the stakes are so high because I describe relocation cases as the nuclear bomb in any divorce, but the percentage of the cases that involve relocation, they go to trial disproportionately on a higher level. And that is because the stakes are so high. Eric is going to want to have a meaningful relationship with his children, and it makes it harder if they're going to school in Houston, Texas, and that he's going to have to go and travel there. He's going to say, listen, my relationship with my children is going to be substantially hindered if even if I can get down there every other weekend, there's a direct flight and travel. Still, my parenting time is going to be in a hotel. I'm not going to be able to cook dinner or attend the Tuesday night recital or the Thursday night sports game. It's much harder. And school just it takes up so much of the social dynamic and schedule that it really can drive those cases to trial. So people are often willing to spend whatever it takes because it fundamentally alters that the relationship between a parent and their children. You can have a PRE or a CFI, they go do an evaluation. Let's say they say, the kids, we talked to the kids want to relocate. And then Melanie's always been the involved parent. And we think that it's in the children's best interest to relocate. Eric, not accepting that, will say, I want now either a supplemental PRE, another PRE, or a PRE that kind of trumps the CFI. And so then there can be this prolonged period of these evaluations because they can take a very long time. And then after that, then each side can get their work product expert to talk about how the expert that they don't like, and because there can be competing recommendations and all this stuff. And the work product expert can come in and say, that evaluator didn't do their jobs. And so they can be extensive, trials because you're getting into crime rates and you're bringing in these witnesses who talk about the relationship between the child and their own kids and their family and all the great things about this particular location. And they can really be intensive trials.
Yeah, and I think also they don't settle and go to trial because there's just not a lot of room for compromise. It's either
100%.
yeah, relocating or they're not. And I think the other thing that is important to mention is that if it's post decree, it does say within within the rules that the court is supposed to make it a priority, is supposed to hear it. So, like, part of the strategy also is like, how soon do you need to relocate? Do you have time to get an expert involved? So that can also play into the strategy and how you move forward.
And the statute does say it needs to be handled on an expedited, basis, but again, it does take some time. You don't just rush these cases along. And even in marriage of Chess said, these are some of the most challenging cases that judges have to deal with. And you talk to judges, they hate SPOMR. They hate relocation, just the idea, but SPOMR in particular, those pre-decree cases, because it requires this abstract, this legal fiction. Melanie is already gone. She's already in Chicago. She's already in New York. And you can't ask why. You can't say you have to stay here. Judges just don't like that. In fact, there was a case, Morgan v. Morgan, where the court said, "All right, Melanie, the mom, you can exercise your parenting time, but all your parenting time is going to be in Colorado." And
Right.
effectively what that meant was, because Melanie testified, "I'm not going to leave if I don't win, if I don't have my kids." And so then the court said, "Okay, I'll see your bluff or I'll force you to stay here," and ordered all parenting time to occur in Colorado. And the Court of Appeals said, "You can't do that. You're restricting someone's constitutional right to live." And so you have these competing constitutional issues. On one hand, a parent has a constitutional right to have a relationship with their child. They have a constitutional right to parenting time in essence. But on the other hand, that parent has a constitutional right to travel. And so the court with these cases is trying to balance that. And in Cheslake, the court, even though everyone says it's harder to relocate, the court explicitly says that both people have the equal burden of proof. That Eric, he's going to be arguing for, and I don't mean to stereotype and say Melanie's always the one that relocates. Eric could have met a new partner and he could say, where he got a job assignment that took him somewhere else. And the other interesting aspect, Amy, that we really haven't talked about is just the Zoom you talked about in the age of COVID. People have more flexibility to work where they're going to work. And that it changes things certainly because Eric or Melanie could say, "Hey, I'm gonna move to Chicago, and Eric, you work remotely. What's the big deal? Like, you can come and work in Chicago, and you can exercise equal parenting time. If you wanna go skiing, because that is like you grew up in Colorado and you wanna go skiing with Ryan because he skis all the time, that's great. You can do that on your non-parenting time, but I have family in Chicago. I wanna move back there, and you can still work there during the week remotely."
Yeah, one trend I've seen in cases is that because the workforce is it's hard to find employees, companies were willing to have people work remote because it was COVID, everyone was remote. But now you're seeing this trend where corporations are saying, we need you to be back here. And so I have a few cases right now where they live in the mountains, but the company is on the East Coast, and the company on the East Coast is saying, we really need you back here. So it's an interesting trend that could be creating possible relocation issue.
Indeed, it is, and there's so many different elements that go into parental relocation that I'll tell you just a couple kind of observations. One is that it's incredibly frustrating to deal with an attorney or someone that just does not understand the law on relocation, where they seemingly think that a court can order someone to live. The other thing on the flip side is that if Melanie comes to me and says, "I'm thinking about relocating," I will have a very lengthy conversation with her about why she wants to, and tell her, "Hey, this is a really important decision. If you're gonna do it, it's easier to do it now. This is going to likely result in the case going to trial, and it really depends on the kids. If you're talking about a 6-month-old baby who is breastfeeding, that is a physiological that there is a real advantage for a mother in that circumstance. If you're also talking about a stay-at-home mom who really is connected with a child, then and the child is young, like 5, 6 years old, that it's not as if it is a done deal, but it that is a much harder scenario for Eric to really object to, or it might not be worth him fighting because he's gotta think about it. And one thing I've talked with other family law lawyers is, what would I do in that circumstance? And a lot of people, it's, "Listen, you should just follow them," because Eric could move to Chicago and follow Melanie if he wants to have a relationship. Not I shouldn't say that if he wants to have a relationship, but if he wants to have the same kind of relationship that he was expecting when they filed, those are the sorts of conversations that can be really challenging, notwithstanding the whole, do we get an expert and the presentation of that particular party's case.
Yeah, I think I would also urge listeners to think about the practicalities of what it's like for the children having to deal with two parents that are in two different states. Because as they get older, even for the parent who has the kids in the summer, they have sports, they have things so it becomes more about the kids and their relationships, not as much, even though as parents were like, we're the most important things to you. That changes over time as kids get older.
Oh, it totally changes over time, and if Eric is the one that wants to relocate and he is saying, "The kids can go to school with me," then is Eric prepared to the traditional paradigm for parenting or relocation parenting plans is Eric has the kids during the school year, but Melanie's probably gonna get a disproportionate amount of the holiday time, so it might be every spring break, it might be every Thanksgiving, it might be every winter break, all of winter break, and then the bulk of the summer. So it could be 6, 8, 9 weeks of straight parenting time for Melanie during the summer. And Eric might say, "Listen, I'm the one that's taking him back and forth between school, and I'm having to do homework. And then, yeah, I get him on the weekends, but the weekends is soccer and lacrosse or traveling around, and I don't get to do really any vacations." And I mean, that there can be that reality. The other thing too, Amy, that you mentioned is kids as they get older, they become, generally speaking, more resistant to going back over the summers to Melanie in this circumstances place. They don't want to leave their friends. And they might have you start sports, they might need to come back and play sports. And the other aspect is if they've traditionally done a sleepaway camp, whose time is that coming in on? And all of those aspects, really, it's something that I think we as family law lawyers really need to walk through our with our clients about what does this look like and positioning that, whether they represent Eric or Melanie, to tell that story and to really look at what are the things that are to our clients' advantage. If the children are older and they've been in a particular location, you're really going to lean into this is their hometown, this is the social capital that they have built up, and we don't know how they're going to do in this other location where their children are really thriving. And then you get into the other practical realities. If Eric has to work and he's traveling for work, can he really be that primary parent? Is he going to have to hire a nanny or some other person? And that's going to be different if Eric is going to get remarried. Then he might have another co-parent or another parent to help him out. But his work schedule might preclude him from really even being considered if he's a pilot or some other profession that, from a reality or a realistic basis, is going to prevent him from taking the kids to school Monday through Friday.
And I think one thing we've really focused on parenting time, but you also see in some of these cases decision making possible changes. Like the parent who is moving, I'm going to know the schools, I'm going to know the doctors. I have more knowledge, so I should get final say. I hear clients, or at least I hear clients tell me that a lot.
Yeah, and then the core is looking at the relationship, the way that people communicate, and on one hand, if Melanie is not going to be the primary parent and they're out, does joint decision making immunize or protect her from being alienated, or there's some sort of gatekeeping? Or on the other hand, does it make sense for Eric just to have sole decision making because he is the boots on the ground and he is going to be the one that makes those decisions because they impact him the most? And there's various, issues with that. The final thing that I'll mention on relocation is that there is a cost, obviously, to the travel, and that can come into play for child support because moving the kids back and forth between households, it is an expense and it is factored into the amount of child support. Arguably, it doesn't include a parent's trip or parent's travel to come exercise parenting time, but to put Sally a plane to go to New Jersey, for example, that is a cost. Then we're going to be looking at the pro rata split of that for child support.
Yeah. And I think just to be clear, and I don't have the statute in front of me, but it does say the child support statute says for a kid under a certain age that it could include some costs for travel for the parent, but not over a certain age.
Right, and that's the reason is that the parent's probably gonna have to accompany Johnny or Sally along for that plane ride, and so absolutely. And then one other point that I'll mention is that PCDMs and or arbitrators, they can be a solution, or they can at least address if, for example, Johnny tests positive for COVID before he's supposed to get on the flight for Thanksgiving. What happens in that circumstance? And if there's a cancellation of a flight, or Johnny has some sort of recital or school play that is going to prevent travel, then what do you do in that circumstance? And those sorts of, they often are time sensitive disputes. PCDMs, parenting coordinator, decision makers with arbitration authority, they generally can step in really quickly and say, nope, this is what we're going to do. And that's going to be much faster, and it's going to be a more thoughtful decision than a district court judge that's just planning a bunch of, or dealing with a bunch of different things. Hopefully, you've learned something about parental relocation. These are gut wrenching, really challenging cases, but they do come up, and the law is allows for each side to have their different arguments. But until next time, thank you for joining us on Divorce at Altitude.